Welcome to Case by Case. This is a podcast brought to you by Luke and Calum Chain of Xyloploid Zadkovich. How are you doing today, Calum?
Doing good, thank you, Luke. How are you?
Good. Been a busy few days. Always enjoy taking a moment's pause from the practice to go over another case with you.
Exactly. It's always interesting to pull yourself out of whatever you're working on and find something else, and also reading the cases without any real agenda, reading them just to see what I actually think about a case, as opposed to normally reading them desperate to find the words that suit our clients is quite an interesting exercise.
Exactly. The neutrality of it is quite liberating in a way. So yeah, we've got another good one today. It's all about off-spec cargo and what happens when you reject, whether you can reject, and what happens when you get it wrong, I suppose.
Yeah, exactly. And maybe we'll start as we tend to with the facts. If that works for you, Luke, I'll get stuck into them.
Yeah, please do. Just before we do, I'll just give the case name of this one is it's the Galtrade case. So Galtrade and BP on the other side. It's a decision out of England, out of the High Court, and was the decision was given by Mr. Adrian Beltrami QC, sitting as a judge of the High Court, and the judgment was issued on the 5th of July 2021. So a nice and recent case. And yeah, please, if you wouldn't mind going through and distilling the facts. It's quite a long judgment on the facts, but I think we can probably cut through quite a bit of that.
I think we can. So this is two oil traders, and they are Galtrade, the buyer, and BP Oil are the seller of 4 parcels of fuel oil. The fuel oil is low sulfur straight run fuel oil, which is neatly described in the judgment as the kind of what Marmite is to beer. This SRFO is to hydrocarbons. It's the stuff which remains at the end of the processing once everything else has been separated out. But that's not to say that it's not excellent as Marmite is.
I always like a Marmite beer analogy thrown into a case by case. Keep going.
There is actually apparently a shortage in Marmite currently in the world because the breweries have stopped producing beer as a result of the COVID crisis and people not going to the pub so much, which is something which is hitting me personally very hard.
Well, you know that I'm no Marmite fan. I'm most certainly a Vegemite fan. But
yeah, exactly.
We are digressing.
That's a dispute for another day, I feel.
Yeah.
So these 4 parcels of fuel oil are being sold FOB at a port in the Black Sea, and as you almost always will see in these agreements, there are a number of different guaranteed values, guaranteed kind of specifications, and it's clear from essentially the first parcel onwards that the fuel oil, the product, is not going to meet those specifications. So we see a number of negotiations between the buyer and the seller. We see the buyer, taking the test results and saying to the seller, we want to knock money off the price. And we see the seller being open to that for one of the parcels. And you've got these repeating issues in each of the parcels, and it's becoming quite clear that the onward supplier of BP Oil is just not providing a cargo which is within the specification. And when it comes to the third parcel, it's clear in the third parcel, or it's clear early in the analysis of the third parcel, even when the surveys of the cargo, the initial kind of sampling comes back, it's clear that the sulfur content is in excess of what's allowed under the contractual specification. I think the recording is 1.47% against 1.3% that would have been allowable. And this kicks off a string of negotiations, ultimately ending in the buyer turning around to BP Oil and rejecting delivery. They simply say, we're not taking it and we're not paying for it. And they ultimately bring a claim saying that they had a large amount of wasted expenditure as a result of the BP Oil's failure to deliver a cargo which is within specification. And then, of course, BP Oil turned around and counterclaim for payment of the fuel oil that was rejected by Galtrade. And there essentially is the dispute. Galtrade say that the specifications, including the sulfur quantity, were conditions of the contract, and that once breached, the contract could be terminated by Galtrade, or alternatively, that they are intermediate terms, and the breach of those intermediate terms is so severe so as to substantially deprive Galtrade of the entire benefit of the agreement, which equally would give them a right to terminate the contract and sue for damages. And that is the question that came before Adrian Beltrami QC, sitting as a deputy judge of the High Court.
Yeah, so we've got a condition versus intermediate contract term case here, and these are fun cases because it's the type of issue that you learn in very early on in contract law when studying it, and it comes up every now and then. It's not on every case you have to do this kind of analysis, but it's a very good habit to get into, to think about, well, if there's a breach of a term of a contract, to first think about what is that type of term. Is it a condition? So a term that really goes to the root of the contract, that if breached enables the other party to walk away and to, in this case, reject the cargo? Or is it something less than that, an intermediate term which can have the effect of a breach of a condition if it's a very serious breach? Or is the consequence of breaching an intermediate term not so severe such that it should sound in damages only and not give this rescission, and that's then analogous to a warranty? So you've kind of got this hierarchy of terms: conditions, intermediate terms, and warranties. And the intermediate terms, almost as their name suggests, can go one way, up or down, so to speak, depending on the severity of the breach.
Yeah, and it's almost the case that, well, it is the case that a very minor breach of a condition is still a breach of a condition. And you see this in a number of different contracts. I remember being a trainee in a real estate seat, and there was in the kind of standard terms and conditions of sale for land in England, there is certain acceleration rights that a seller or a buyer can exercise, and they state quite expressly time is of the essence if certain payments haven't been made. And those terms are quite clearly conditions. They're expressly conditions. That wording of the essence has been held to elevate a term from what might be an intermediate term into a condition. And a breach of a term which is of the essence, even a minor breach, is enough for the innocent party to have a right to terminate the contract and sue for damages. I guess in the shipping context, the two big ones recently have been the spar shipping case, and there's this debate which has raged on for a number of years as to whether failure to pay hire is a breach of a condition or a breach of an intermediate term. And as the law currently stands, it's an intermediate term, but for a long time it was a condition, and different cases went different ways on that. It's a very interesting question, but I think it's probably right to say that hire sits more neatly as an intermediate term rather than a condition.
Yeah, exactly. And you see that also in commodity sale context when you're dealing with loading periods and what date needs to be on the bill of lading for the loading period, because often you'll have time of the essence provisions for when cargo needs to be shipped by, and that's often because subsequent sales require shipment within a certain time frame. It's also often pegged to price as well. So when the cargo is shipped will determine what price to apply. So you do see these time of the essence conditions in commodity sales as well. And so the starting point really is to determine whether the quality provision in this contract was a condition or not. And there's a number of tests that go to this. In this particular case, we weren't dealing with when the condition is expressly set out in statute or that it's the result of previous judicial decisions. And we're really focused on where the nature of the contract, and I'll read the quote here from the decision, where the nature of the contract or the subject matter or the circumstances of the case lead to the conclusion that the parties must, by necessary implication, have intended that the innocent party would be discharged from further performance of his obligations in the event that the term was not fully and precisely complied with. So thinking about that in this context, what we're saying is that because the seller failed to provide product that was on spec and that it fell short of the specifications you've described, that whether that was something justified the buyer to walk away entirely because that term, that specification clause, was not fully and precisely complied with. And you can see how that's quite a high bar on a quality provision when the product is still marketable. It's not a case of that this product can't be used at all because, say, sulfur regulations meant that it's completely unusable. But this specification could still be sold at a reduced value, of course, but there was still some value there.
Yeah, I think there's the key difficulty that I was actually surprised when I read this case that they ran an argument that this would be a condition. That strikes me as a very difficult argument, and I was not surprised that the judge, or the court I should say, found against that argument on a number of different grounds. But the most striking to me was, okay, in this case there is a big difference between the allowable sulfur content and the actual sulfur content. It is a long way away from the contractual specification, but if this term is a condition, then the slightest breach of that specification, the slightest elevated sulfur content, is enough to essentially tear up the entire contract. And that to me is not how these contracts are dealt with. It's not how parties expect the specification to be adhered to. Of course, a buyer wants to make sure that their product that they purchase is within the specification, and of course, a buyer wants to have a remedy if their product falls outside of that specification. But to say that the remedy that they're entitled to for the smallest possible breach, for anything short of full and precise compliance with the specification, is a right to terminate the contract, a right to say the contract is torn up and the buyer is able to claim in damages for all the costs of that failure to provide an on-specification product, is just so overblown a remedy that I was not surprised at all that this disappeared.
No, I agree. I entirely agree. And it's also this point about, can the buyer be compensated by damages? And that's really a fundamental consideration in these types of cases. If a slight deviation from the obligation can easily be compensated by damages, then it's not the type of clause that you would envisage being a condition. And I think it's much of what you're saying there as well. So I too, this is one of those cases where we both agree, and we respectfully agree with the court as well. We'll probably end up eating our words with the Court of Appeal decision in a year's time. Something
exactly,
in this case that we haven't actually seen, or an instruction.
Yeah. One point I did note from this is that the test for getting something to a condition, the way that the courts and the way that authorities, and they look at Chitty, which is, for any non-lawyers, that's the seminal text for practitioners on contract law, which is often referred to in the court. So they look at the relevant section on Chitty, and they look at the other decisions on this question, and it is a difficult thing to do, to argue that a clause in a contract is a condition without some kind of help from previous case authority to say clauses of this nature are conditions, or alternatively without some wording of the nature that we've previously discussed in this podcast, is of the essence. It's a hard bar.
Yeah, I agree. So what ended up happening here with the consequences of it? So we know that this was not a condition. It then falls to be a intermediate term, and we then look at whether the consequences were such that it should be effectively treated like a condition and give the right of rescission, or whether damages are sufficient. I think we've already kind of gone to that point, in that this is the type of breach which can be compensated for by damages. The seller went on to sell this cargo at a loss, but still sold it and recovered money for it. And there is a loss there, in providing the off-spec cargo, which could, from the buyer's perspective, be compensated for by damages. But what they did is, instead of just bringing a damages claim for the off-spec cargo, they rejected and incurred some costs dealing with the cargo that resulted from their decision to reject the cargo, and then brought a claim for those wasted expenditure costs. But they did that under the rejection. And because this clause was not a condition and didn't have the effect of being a condition as an intermediate term, that was a wrongful repudiation of the contract. And so the additional costs that were incurred by the buyer were effectively brought about by their own breach of contract in wrongfully repudiating the contract for providing the off-spec cargo.
Yeah, so it all turns on this question of, so it's not a condition, the court disposes of that question pretty quickly. So it is therefore an intermediate term, which means that if the breach of the intermediate term is so serious that it deprives the buyer of basically the entire benefit of the contract, then despite the fact that the term is not a condition, the buyer still has that right to terminate, but only if the breach is really, really serious. And as you say, Luke, only if the breach can't reasonably be remedied with a payment, or at least that's a factor in the court's decision. And they looked a lot in evaluating that question at things like industry norms. They said that where you have two traders of petroleum products, then they're used to taking products of different standards and blending them, mixing them, reselling them with, in a different form. None of this is hugely unusual for each of the parties. And something that I found quite interesting as kind of a practice point, if you're in this situation where you're thinking you might want to reject a cargo, is that the court specifically referenced the fact that the claimant, the buyer, sought to negotiate a discount on the parcel. They said, the very fact that before you rejected delivery, you tried to get a discount, even though that discount wasn't given, it was clear that in your mind, you thought that this was a problem about value. It wasn't a problem about the contract, or it wasn't a problem about, it was a problem about the costs and the value of the goods. And if it's a problem about value, then the court can deal with it, and they can make sure that you get the balance of the lost value in damages, which would have been the appropriate thing to do. And that, I suppose, that's the point at which the house of cards falls down for the claimant here. They were wrong to reject. The rejections caused by their breach. Their claim therefore fails for all these losses, and the seller's claim succeeds to demanding payment for this cargo. So it's kind of a cautionary tale. I suppose this is one of the questions that lawyers perhaps don't like answering. Is the breach here sufficient for us to terminate? Is a difficult question for a lawyer to answer, because they're going to want to be very, very sure that the breach is so serious that they have this right, that this right to terminate has accrued. And in the that's going to be in the context of the contract that's being discussed. Has your client in that situation lost the substantially the whole benefit of what they contracted for? And it can be a delicate question to answer, as was the case here.
Yeah, and it can be delicate as to how to deal with it. As going in and starting to negotiate on value may not be your best move if you're going to pull the trigger on repudiating the contract. So there's a lot of nuance in there, and it's important to tread very carefully through this. So yeah, I thought it was an interesting decision. It ended up in an award of nominal damages in both directions, and it really shines the light on conditions, intermediate terms, in the context of off-spec cargo and quality claims. And I think it's fair to say that it's a high bar to make good as a buyer, a rejection of cargo argument when you're talking about quality, when that quality, as I say, can still be sold for good value.
Yeah, I think that's definitely true. I suppose there are situations. That said, it is difficult, no doubt, but there are definitely situations where you can envisage that a contract has been repudiated, and I think I think people are rightly cautious about it. I think this case emphasizes caution. I think that there was perhaps an element of impatience here on the buyer's part to, the first parcel had been substandard, the second parcel had been substandard. They get the initial test results for the third parcel and they just think, oh, enough of this, and they want rid of the contract. But there are certainly situations that you can envisage where repeated failures or egregious failures would equate to a sufficiently serious breach of a intermediate term. And it's just in the context on these facts, they weren't there. It wasn't sufficient enough. The uplift in sulfur content between what was contracted for and what was actually delivered wasn't enough to substantively change what they were being given. They were still being given this type of fuel oil. It was just a slightly more sulfury type of the same type of fuel oil, which a person in the buyer's business should have been able to mix, blend, sell. Of course, at a loss. Of course, they're going to lose some money on this parcel, but they still have the right to claim that in damages. What they don't have the right to do is to say, enough, we're walking away. And that's the key point, I think, to take away from this case.
Yeah, I think you've summed it up really well, Calum. Yeah, I agree. Good case, good summary. I think this is one of our shorter ones, which is, there you go. We can wrap this one up. Maybe we're getting more efficient.
Exactly.
Either that or it was a more straightforward one, which we didn't disagree on. All right, good stuff. Thank you everyone for listening in. We're grateful for your time. I hope you found this interesting. If you did, please share it with your colleagues and your teams, and subscribe to our channels on Spotify and on Apple Podcasts, if you don't mind. We appreciate the support. Until the next Case by Case, take care.
Cheers, Luke. Cheers, everybody. Bye.